Across ASEAN markets, environmental, social, and governance reporting has permanently migrated from a corporate branding exercise into mandatory compliance infrastructure. It is now a hard access condition for maintaining trade with European supply chains. Incoming European Union regulations treat sustainability data as concrete inputs for customs authorization and liability allocation. Specifically, the Corporate Sustainability Due Diligence Directive, which requires companies to mitigate environmental and human rights impacts in their value chains, and the Carbon Border Adjustment Mechanism, a tariff system pricing the carbon emissions embedded in imported goods. To stabilize cross-border legibility and appease EU regulators, ASEAN jurisdictions are rapidly adopting the ISSB global baselines. The ISSB, or International Sustainability Standards Board, issues frameworks like IFRS S1 and S2, which act as standardized templates for general sustainability and climate-related financial disclosures. This convergence creates a dangerous misconception among procurement officers and investors. They observe perfectly matching IFRS S2 headers and identical data fields, and assume that because the format of the ESG data is standardized, the reliability of that data is equally secure. Template convergence improves comparability, but it does not equalize accountability. A shared reporting grammar is an illusion if the domestic legal machinery tasked with enforcing it remains weak. To understand why, we look to the comparative law theory of legal transplants. This theory examines what happens when specific laws or regulatory standards, like the ISSB frameworks, are exported across international borders. Transnational norms are never directly adopted in a vacuum. They undergo a process called institutional recoding, where the imported rules are adapted and transformed to fit the host country's pre-existing statutory habits, regulatory bodies, and court practices. Consequently, the actual enforceability of any ESG statement depends entirely on the domestic machinery that verifies, contests, and sanctions those specific claims. A jurisdiction can publish globally legible, perfectly ISSB-aligned reports while simultaneously operating a local accountability system that is opaque, painstakingly slow, or entirely insulated from public contestation. To measure true compliance risk, we evaluate a jurisdiction through the accountability channel. This is a novel, four-part analytical framework mapping the exact institutional route a sustainability disclosure takes from initial statement to final sanction. Pillar 1 is the vehicle. This is the formal mechanism through which information enters the legal system. It dictates whether a disclosure is governed by a contractual listing rule on an exchange or submitted as a strict statutory state filing. Pillar 2 is the actor. This identifies the specific entity that verifies claims and initiates enforcement. It highlights the difference between a centralized, agile exchange regulator and a dispersed network of administrative courts. Pillar 3 is the pathway. This outlines the route for legal contestation, contrasting closed, market-mediated dialogues against open, highly juridified public lawsuits. Pillar 4 is the sanction. This catalogs the remedial consequences available, ranging from predictable financial penalties to highly disruptive operational injunctions. ISSB alignment only happens at the vehicle level. The remaining 3 pillars determine whether that compliance is credible in practice or merely performative. Singapore is a common law jurisdiction. Its legal architecture relies heavily on continuous, exchange-led supervision and clear, market-visible signals to enforce compliance. Broad sustainability reporting enters as a continuing listing obligation under SGX Rule 711B. It is anchored in contract and supervised rapidly by Singapore Exchange Regulation, or SGX RegCo. However, Singapore utilizes a secondary statutory vehicle specifically for large emitters, the Carbon Pricing Act 2018. This fiscal anchor imposes severe discipline. With carbon tax rates hitting SGD $45 per ton in 2026 and 2027, voluntary emissions data is converted directly into an administrable, audit-ready tax base, rigorously verified by the National Environment Agency. Dispute resolution remains administrative and market-mediated. Regulators rely on rapid query and correndagem tools, resulting in bounded, predictable sanctions like public censure or strict fiscal liability. Singapore's model achieves continuous calibration. The jurisdiction sacrifices extreme judicial remedies in favor of a constant stream of rapid, highly visible micro-corrections. Thailand operates under a civil law system. Here, ESG disclosures are embedded deeply into formal statutory filings, paired with constitutional logics that prioritize public participation. ESG disclosure is integrated into the mandatory statutory Form 56(1) report. Compliance is supervised primarily by the Securities and Exchange Commission, Thailand. Thailand's distinct pathway is administrative legality review. This mechanism allows affected parties to directly challenge both state and regulatory action regarding environmental governance. This creates significant remedial bite. In 2025, the Supreme Administrative Court forcefully ordered the state to designate PM 2.5 pollution control zones, directly overruling regulatory resistance. A parallel private law pathway also exists. The Class Action Act allows plaintiffs to pursue collective civil liability against corporate directors for any false statements published in the Statutory 1 report. Thailand's model represents episodic contestation. While routine errors might pass slowly through the system, high salience disputes trigger an expanding web of disruptive, existential legal remedies. To stress test these two machineries, consider a specific hypothetical. A supplier operating in both jurisdictions materially underreports their Scope 1 emissions, which are direct greenhouse gas emissions from owned or controlled sources, due to negligent boundary setting in an IFRS S2 aligned report. In Singapore, detection occurs vertically. The discrepancy is caught through the strict carbon taxation measurement and verification protocols. SGX Redco issues a public query. The firm publishes a rapid corrigendum, and the state adjusts the tax base. The data is cleaned efficiently without causing corporate paralysis. In Thailand, that exact same data defect travels horizontally, exposing the firm to multiple simultaneous vectors of attack. The SEC demands a statutory restatement. Simultaneously, the misstatement becomes evidence for investors' civil liability suits, and affected communities file for license-affecting interim relief in the administrative court. The same data defect cleans itself quietly in Singapore, but potentially crystallizes questions of fundamental legality and massive financial liability in Thailand. This chart plots jurisdictional risk across 3 variables: speed, visibility, and remedial bite. Singapore plots high on speed and visibility, but remains moderate on remedial bite. Thailand registers low on speed and visibility, but spikes to the maximum on remedial bite. Neither model is inherently superior. Singapore protects market efficiency, while Thailand protects participatory governance. However, they generate entirely different risk profiles for corporate reliance. For EU-facing counterparties, the legal directive is clear. Do not treat ISSB-aligned sustainability reports as fungible compliance signals across jurisdictions. Under the CSDDD and CBAM directives, standardizing the format of supply chain data offers no legal shield if the local enforcement mechanisms verifying that data are weak or non-existent. Practitioners must shift away from basic template review and systematically map the accountability channel for every jurisdiction of operation. You must build channel-specific verification. In Singapore, mandate carbon pricing audits. In Thailand, assess administrative court exposure. The ISSB standard provides a highly legible global vocabulary, but it is only the domestic legal machinery that provides the guarantee.